The legal battles of Louis Vuitton, Tesla, MUJI, and New Balance with Chinese copycats speak volumes about the risks of doing business in China. Even the Trump and Bush names are victims of trademark squatters who registered those names as their own. But Shuanghuan Motors, the grandfather of Chinese copycats, has a serious lesson for all copycats.
Hi, I'm Lei. Welcome to my show. Today we'll talk about how multinational brands have been fighting for their trademarks and logos in China. This is the third video of my copycat trilogy. You can check out my previous two videos at the end. Luxury brand Louis Vuitton has not only been fighting counterfeiting in China, but also trademark squatting. In 2002, Wang Jun, a Chinese fashion merchant in Wuhan, discovered that Louis Vuitton had registered only Chinese and English trademarks, but not its design patterns, and also that the Chinese trademark had expired. He immediately applied to trademark Louis Vuitton and its Chinese name, as well as the company's patterns. In October 2003, the State Intellectual Property Office of China granted Wang the trademarks. In 2004, Louis Vuitton appealed. After more than 2 years of review, the agency ruled that Wang's trademarks were valid. In April 2007, LV appealed again, and Wang threatened to mass-produce the Chinese version of LV products. In 2009, the Beijing First Intermediate Court ruled against Wang Jun, and LV finally got its logo and patterns back. Patent squatting is a common problem that multinational companies experience in China. Electric car maker Tesla experienced it when it first entered China. As early as September 2006, Guangdong cosmetic merchant Zhan Baoshen applied to register the Tesla trademark on 12 categories of automobile products and was approved in June of 2009. He then used the name and logo for his own products. Tesla tried to settle with him but failed, so it filed a lawsuit in 2013. In August 2014, the Beijing court announced that the case was under mediation, and eventually it was settled in the same year. The amount of settlement was not known, but Chinese media reported that Zhan Baoshen said that he was very satisfied with the amount. Former U.S. President Donald Trump also had a trademark battle in China, and it lasted for 10 years. In 2006, he commissioned a Beijing law firm to apply for the Trump trademark in China. In 2009, the trademark office rejected the application because a man from Shenyang named Dong Wei registered the same trademark 14 days earlier. Trump fought lawsuits for nearly 10 years and was dismissed at least 4 times. It was not until he was elected President of the United States in 2016 that the Chinese authorities invalidated Dong Wei's trademark and approved Trump's. Interestingly, the timing of the approval was November 13, 2016, 10 days after he was elected President of the United States. Now, Trump is not the only U.S. president with squatter interest. In 2004, a Chinese businessman applied to trademark the Chinese name of former U.S. President George W. Bush for use on diaper products. But his application was rejected because the use of the names of national leaders may have an adverse social impact, according to the Chinese official response quoted by the New York Times Chinese edition in 2016. However, not everyone has the chance to be president and treated favorably by the authorities. The Japanese brand MUJI, for example, is not so lucky. Its logo, products, stores, and styles are closely copied by the Chinese brand Natural Mill. The two Chinese logos and brand names are exactly the same. The only difference is the English name. MUJI started fighting for its trade name in China as early as 2001. After 18 years of legal battles and multiple appeals, MUJI lost the case in 2019 and was ordered to pay the Chinese copycat 625,000 yuan, or about $100,000 for losses. The worst of it is that MUJI itself cannot use the Chinese MUJI trademark on 24 of its own textile products in China. But hands down, the most outstanding drama involving trademark battles is that of American athletic shoe brand New Balance. When New Balance entered the Chinese market in the 1990s, its Chinese brand New Balance was underhandedly registered by its Chinese partner, Yangjiang Youlian Footwear Company. Using this trademark, the Chinese company produced large quantities of counterfeit products, causing severe losses to New Balance. As a result, New Balance withdrew from the Chinese market. In 2003, New Balance returned to China and registered the trademarks New Balance, NB, and the trademark letter N. However, it forgot to register the Chinese translation of the name New Balance. As a result, the Chinese New Balance and New Balun were registered by a Chinese company. Various Chinese translations of New Balance also sprung up in the market. In 2013, Zhou Lelun, the owner of the Chinese New Balance trademark, filed a lawsuit against New Balance for infringement. The Guangzhou Intermediate Court ruled in 2015 that New Balance immediately stopped using the Chinese New Balance name and compensate the plaintiff 98 million yuan, which is about $50 million US. New Balance was also ordered to publish an apology on the New Balance Chinese official website. The amount was later reduced to 5 million yuan, but New Balance kept fighting on. In a decision on January 5th this year, the Shanghai Huangpu District Court ordered the Chinese company and its manufacturer and distributor to pay damages of 25 million yuan or $3.85 million to New Balance. The ruling came at the time when the Chinese top leadership is greatly concerned about the ongoing decoupling trend from China and may be intended as a friendly gesture toward outside investors. Winning this case, however, is significant for New Balance after 2 decades of battles. It's also worth looking at the fate of a Chinese automaker that can be called the grandfather of Chinese copycats. Shuanghuan Motors was established in 1988 as a repair and remodeling shop for Chinese-made military jeeps. In the 1990s, it made its first car by copying Jeep Cherokee. It even had the word Jeep printed on the car's body. Its second car was a SUV called SRV, which is a copy of Honda's popular CRV. In 2003, Honda sued Shuanghuan Motors for copying the CRV. But the Chinese court ruled against Honda, and the company had to compensate Shuanghuan for economic losses of 16 million yuan or about $2.4 million US. Its third car, an SUV called SCEO, was an alleged copy of the BMW X5. BMW did not sue Shuanghuan initially, but when Shuanghuan planned to sell the copycat SUV to Europe, BMW filed a case and blocked the copycat X5 from entering the German market. Within its 28 years of history, Shuanghuan made only 4 cars, all of which were copies. Its S6 was a copy of Mercedes-Benz smart car and was called the Chinese Smart. Blinded by the short-term benefits of copying, the company didn't invest in R&D, had no new products within 8 years, and lacked the ability to solve technical issues. This eventually led to cash flow problems and the withdrawal of dealers. When Shuanghuan was in crisis and sought external help, no domestic or foreign auto groups ultimately offered to acquire the company due to its poor reputation outside China. It was ordered to close in 2016. The bankruptcy of Shuanghuan is a lesson that all copycats should learn. Shuanghuan isn't alone. Warren Buffett-backed Chinese automaker BYD also started as a copycat. I made a video on how BYD and cell phone maker Xiaomi rose to prominence by being copycats. You can click here to watch. Click here if you want to understand the Chinese copycat phenomenon from a cultural perspective. Don't forget to like and share my videos. Stay tuned, more will come.